Hi, Jeff Mersanti, the Plain English Attorney, and welcome to the live stream. And today we are talking about Estate Planning 101. So we're going right into some of the very basic documents that are out there. It's the ones that are really commonly heard of. We're not going to get too deeply into avoiding probate and using trusts and other things like that. That's going to be for Estate Planning 201 and beyond. But for this one, we're going to talk about just those basic documents. These are really for people just getting started with estate planning. Maybe they haven't accumulated a lot of assets. They're just getting out and building things in the world, but they want to make sure that they're protected. In particular, this would be something very appropriate for my clients that maybe they've got their revocable living trust set up. Maybe they've even got some IRA and asset management trust or beneficiary trust set up. So they've got their planning down. But it's their kids that are in their 20s or maybe even early 30s. And it's like, all right, they got to get them covered with something that may be healthy. There's no big issues. But look, you got to have something because we just never know in life. All right, so what we're going to cover are the 5 biggest documents. Now, what exactly are we really doing in covering here? We're talking about situations that cover both health and finances, and it's if you become incapacitated or after death. So it's different phases in different areas of your life. So we'll start out with the big one that everybody hears about with estate planning. It's the last will and testament. Right, a last will and testament is your orders to a court saying, hey, here's how I want my assets distributed if I pass on, again, after death. After I pass on, here are the people that I want named to administer this. So they would be the executors that are listed in there. And it also has several formalities that need to be in place just to make sure that everybody is clear. This is your last will and testament, meaning it's the latest one that you're putting together. And part of it is you're going to revoke all, quote, prior last will and testaments. So the most recent one is the one that controls. And you have to state just the very basics that you know basically who you are, who your kids are, the natural heirs of my bounty, and it's got to list how you want your assets distributed. And it could be very simple in like, hey, I want everything to go equally to my parents, or if I've got kids, equally to my kids. So that's the kind of threshold for putting together a last will and testament and the other documents. It's testamentary capacity. So as long as you have that capacity, great. So there are points in the will that go directly towards stating that. So another thing that I sometimes see is people listing guardians. Well, that's going to be the bonus document that we talk about. Out of the big 5, if you actually have kids, that might be the time to start looking at a revocable living trust or a little bit more advanced planning. But at least for now, there's that last will and testament. Now, it does mean that your assets go through probate. So that probate court process is going to oversee the distribution of your estate, make sure that all your bills are taken care of, all of those final expenses are handled, and it's going to make sure that there's a recording of all of your the expenses with the invoices matched up to the canceled checks, and so that everything kind of balances down to the penny, so there's no money that goes missing. This does make things a little more expensive, but really you're weighing that against a revocable living trust, which could be wholly appropriate depending on your situation, to avoid all that court stuff. But you're also taking a look, how old are you? Are there any health conditions? And look, if everything's fine, the odds of something happening to you go down. On the other hand, if you're jumping out of airplanes and rock climbing without being tied to a rope or anything like that, okay, your risk goes up. You've got to balance and decide for yourself how you want to handle that. But the last will and testament is the main document. Second big document, this is the durable general power of attorney. Now, this is allowing someone to handle financial things for you. And unlike with the will, this is only only during life. So here's how these things match up on the financial end. Your financial power of attorney lets someone else and puts someone else in charge to take care of financial things for you. And that's the way to think about it, financial. It's a broad range of things, but it's up until the point you pass on. The whole theory behind it is I want this person to be able to do anything that I can legally and financially. Nothing to do with healthcare, but everything else gets put into that financial power of attorney. Now, the way we set this up is it's a durable general power of attorney. Look, that's just legalese. Durable means it's going to be in effect even after you become incapacitated, which is what most people want. And it's a general power of attorney, so it covers a wide range of areas. Now, here's something that a lot of people kind of get wrong on this, and understandably so. Oh, the power of attorney is only there in case I become incapacitated. Technically, again, using the legal jargon, that's a springing power of attorney. It only springs into effect. Thing is, you go back about 10 years, maybe even more, there was this big debate going on within the state bar, especially in the estate planning field, about whether or not you should be doing springing powers of attorney. And the reason they were doing this is banks and other financial institutions were getting so ridiculous with the forms that they wanted people to fill out and have doctors fill out to attest to the fact that, yeah, this person's incapacitated. And if it wasn't to the bank's satisfaction, they weren't giving control. So all of these powers of attorney had things come to a grinding halt because the doctors weren't filling out these longer forms. Here's the thing. You get a busy doctor. Hey, doctor, can you please just write out on a note that the person's incapacitated? Not a problem. This person's incapacitated. They're unable to handle their own affairs. The power of attorney should step in. Done. Now it's a 5-page form, and here's where this has to be filled out, and this has to be filled out, and you've got to check these boxes, and then maybe even, and it's got to be notarized. Okay. It got so bad, and things were being held up so long with the doctors just, I don't have time to fill out. I don't have time to fill that out. And suddenly it's 2 weeks later, the doctor hasn't gotten to the form because it's so much that they just said, all right, look, make it effective now. So, look, that shouldn't be a problem. If you are putting someone in as your power of attorney, you should be able to trust them to not steal your money now. If you think there's a possibility that they could go and take this power of attorney and use it while you're fine and start stealing your money, that's not a problem with the document. That's a problem with the person that you chose to be in that position. So we have this durable general power of attorney. It's effective now for that first person. And then there's the backups. We'll go into that a little bit more, the backups and everything. So that's covering before passing on. And after death, it switches over to the estate, and it's the executor that you've named in the will. Now, what about on the healthcare end? This is where we have 2 more documents. There's the living will. Now, I'm jumping to that one first because whenever I say healthcare power of attorney, which is another document that we're talking about, they go, oh, well, who's going to pull the plug? No. There are some states that have that. The living will makes that determination. You can put your wishes in there ahead of time, just on that, and you're taking that decision out of the hands of your healthcare power of attorney. So the living will just basically states, if the doctors have determined that you're terminal and incurable, you're in a persistent vegetative state, in short, they've tried everything they can, and look, you're not coming back. But we can keep the body going on the machines and the nutrition and the hydration and keep our fingers crossed and knock on wood and pray for a miracle. Most of my clients at that point are like, no. If I reach that point, just let me go. And that's what the document covers. We get to the healthcare power of attorney, and now suddenly you're naming people in a succession. to cover all of the other healthcare and related decisions that could come up. Now, I'm going to talk a little bit. There is a living will with advanced directives that is so much more detailed. And okay, if this happens, then I want this, or if this happens, I want this. It's kind of the way I look at it. You're taking decisions and flexibility away from your healthcare power of attorney by mandating certain things. Now, the example I'm going to give is there's this document out there called the 5 Wishes document, and everybody praises it up and down. Basically, it's like a fill it in yourself power of attorney, but they don't really say that. But it ends up being in writing, signed, witnessed by 2 people, and notarized. It's like, yeah, that's your power of attorney and a healthcare power of attorney kind of wrapped up. And I had a client that had this. It's like, yeah, how about this one? No, we're going to replace it. Well, check this out, and this is what I want. All right, they had written in specifications, no amputation. Now, they were type 1 diabetic, and what they really meant was, okay, if you get to the point where you're going to cut off an arm or a leg, I would rather you just let me go. All right, that's legitimate, but that's not what that said. It said no amputation. Now, if you were in a coma and the doctor saw that and you had an infection right there, the little tip of your pinky, and it could have been, okay, they could have amputated, you could have lived another 20 years just fine. Nope, sorry, nope, no amputation. It's in the document. You're not allowed to do. That's not what you mean. You're taking away the flexibility of your healthcare agent to be able to say, no, I had a discussion with them. I know what they want. Go ahead and amputate that little thing. Oh, they're going to take off your legs. They said they would rather let it go. Just don't do that. So getting so specific, except for that very last one, where it's at the very, very, very end, you don't want to put that emotional burden on them for saying, yes, I told the doctors to pull the plug, not they made the decision ahead of time. So you want your healthcare power of attorney to have as much leeway and authority to make decisions as they come up without really pigeonholing them into specific decisions because you wrote it out ahead of time. So this is why I still use the, quote, old style living will with my clients. And we have a very robust healthcare power of attorney. Now, what is that 5th document then? Okay, the 5th document is actually a hybrid. It's a nomination of conservator. And when I say hybrid, it's handling both medical and healthcare as well as financial. This is the document where if you're out of it for such a sustained period of time that someone feels they need to go to a court and become your guardian, all right, this lists the people that you want. Now, the way we do it, we line everything up. It shouldn't be necessary if you've got your financial power of attorney and you've got your healthcare power of attorney. But sometimes things happen. Sometimes there are financial institutions that aren't taking the power of attorney. There's someone else insisting on a guardianship. Somebody thinks things aren't going the way they should be and they're going to apply to a court. All right. But what we put in, you have a conservator of the person, and that's going to line up with your healthcare agents, and there's a conservator of the estate. That's going to line up with your power of attorney people. So that's the hybrid document. Now, another very important point that I'm going to put out there, in your durable general power of attorney, the financial power of attorney, and the healthcare power of attorney, one of the things that we put in there very specifically in both of these documents, it's a HIPAA waiver. So there's the healthcare privacy features in the HIPAA laws that prevent the disclosure of medical information. Well, in those documents, it's right in there stating, okay, the healthcare agent gets this medical information. They're waiving their right to privacy. And same thing in the financial. Well, why the financial? Because if you may actually end up being in this position where you've got one person who's doing your healthcare decisions and a separate person who's paying the bills, and the hospital saying, Here's a bill for $10,583.15. Well, okay, what's the itemization? Oh, we can't tell you what procedures they had and what the costs were because that's covered by HIPAA. All right, it's already in the document. So I sometimes see people freaking out. They just look at the documents and go, where's the HIPAA waiver? We put it right into the documents so it's not unintentionally left home or left behind or not part of the paperwork. That language is in both of those documents. All right, so that's the big five. What is the bonus one? All right, if you do have children who are minors, or they're adults, but you are actually still a legal guardian for whatever reason, naming who would be good guardians for them is something that you also need to do as part of your planning. So we have an appointment of guardian or an appointment of guardian form that lists out the people who you want. Now, let's go a little bit into, wait a minute, we keep talking about people being put into these positions and what exactly are the, who am I going to put here? Here's just a couple of tips to run through. What we typically do, and I run my clients through this, it's the big four questions. Not too complicated. I think a lot of other attorneys make this a lot more complicated than it needs to be. In fact, I'm working with a client with substantial estate, and the whole thing is kind of disjointed. It's not coordinated, and I just know they kind of went through, well, all right, who do you want as your executor? Who do you want as your trustee? Who do you want as your power of attorney? Look, it's all one question. That first question is, who do you trust to handle financial things for you if you can't? All right, so the scenario that I lay out is if we put all these documents together and everything's fine and you drive out and then bang, you're in a car accident. You end up in the hospital in a coma. All right, who's the person making sure that all the bills are taken care of, everything is, money's moving around, everything's fine, so that in 3 months when you get out of the hospital, you're not returning home with utilities turned off, things being repossessed, or you're kicked out of your apartment for non-payment or any of that other stuff. No, they keep your financial life going. But if you don't make it out of the hospital, you actually pass on. All right. This is also the person who's going to be in charge of making sure that everybody gets what they're supposed to get and when they're supposed to get it. So we're looking for one person. If they can't do it, there's a backup. And then if they can't do it, we have a third person. All right, easy enough. Second big question, it's that same exact scenario, but now who's the person who's going to be in the hospital talking with the doctors, deciding on courses of treatment, surgery A versus surgery B, and signing all the medical paperwork that comes along with being in the hospital? Who's going to do that for you? So you trust their judgment and you trust them to make these types of decisions for you. They're kind of in tune with what you would want. Again, it's that one person. If they can't do it, there's a backup. And if they can't do it, there's a third. There is no necessity for that first list of financial people to line up with the healthcare people. It doesn't have to be one and the same person. And we'll get to that in a little bit. Third big question is the estate piece of it. Who gets what, when do they get it, and how? So this is the estate piece. It's a lot of my clients don't necessarily like this because I end up killing off their loved ones in these scenarios to see where the money goes. So we have a couple of layers of contingencies that are built in when we're putting this into the will. All right, so a very typical, okay, I want everything to go equally to my spouse first, or if they pass on equally to my kids, if one of my kids passes on, then that child's share will drop down to their kids, meaning the grandkids. Very, very common. So that's 3 layers. That's good. If there is no kids, well, I want everything to go to my spouse. If not, then it goes to my parents or to my siblings. Okay, we can list that out, but we do list in some contingencies. And the other thing that we put in there, if it is for a younger beneficiary, we're going to put in an age of inheritance. I don't want to go too deeply into that, but if you're doing this through a will, it ends up being through a testamentary trust, meaning the will springs up this trust to take care of them, but that does kind of mean it's going to be supervised by the court until they reach those ages. All right. Fourth big question, This is if you've got kids, and it's who do you want to raise your kids if anything happens to you. Now, so that's the big four questions. What are some of the advice? Don't do anything. Oh God, that's just a disaster. Why would you do that? It's not doing anything other than doubling the amount of signatures and paperwork that needs to be done. And if there is a disagreement, then okay, what happens? Oh, well, you can just go to court, or you could just go to arbitration, or you could just go and do some formal thing. Now look, one person at a time. That's how you want it. Particularly with the guardians, I hear a lot of, oh, well, I want my brother and sister-in-law to be guardians. No, there's a 50% divorce rate out there. You do not want to name two people who could be divorced by the time anything happens as, oh, they're going to be the guardians. No, you want your brother to be guardian. Your sister-in-law just kind of happens to be there. Now, this is also something that pops up. Look, we've known them for years. Even if they're divorced, I'm sure that my sister-in-law would be the best person. Right? Fine. Name her second. But you want at least that 3 list, but you want individuals in there. So that's looking at that 50% divorce rate that's out there. It really does kind of make sure that you don't want to name couples. And certainly, oh, well, let's name all 3 kids as co-executors. That's, again, a huge mess that you really don't want to have to deal with. It's not necessary to do that, just one person at a time. Next piece of advice is if you're running through these people and you're writing them down and suddenly you're starting to cringe a little, it's like, I don't know if I want them to be able to have this power and authority. Come to, step back, take a look, and think about who you actually trust to do these things. I have a lot of people jump to, oh, well, it's got to be my parents, or it has to be my oldest child. No. For the financial question, it's who's really going to be the most financially responsible and able to handle those things. They don't need to be an accountant or a financial advisor or an attorney or any of that stuff. They just have to be able to manage the money and spend it appropriately on your behalf, and they're responsible with it. Healthcare decisions, look, they don't have to be doctors, but they have to at least be knowledgeable enough about what you want and be medically curious enough to ask questions. And you name that, again, that one person. They can always talk to other people and get support, but it doesn't mean that you have to have multiple people lined up. And this final third point, stop trying to look for Superman or Supergirl, or Wonder Woman. Just don't think, well, this person needs to be able to do financial stuff and make the healthcare decisions and raise the kids. Look, there are some very dynamic people out there. Maybe they can be the power of attorney and executor, healthcare agent. They can raise the kids and be in charge of the estate. Maybe they can do all of those things, but they don't have to. And plenty of families have, and friends, you've got someone who's really good with numbers. They'd be very good with taking over the financial things and making sure that everything's in order and documented appropriately. And okay, we're going to put them in charge of finances. Do you want them raising your kids? Oh gosh, no. They're working like 16, 17 hours a day. They would never have time. Okay, you can name someone else. Do you want them making medical decisions? Oh gosh, no. They are some of the coldest, most unempathetic people that I know. They're good at numbers. All right, well, someone who's making healthcare decisions could be very, very empathetic, but horrible with money. And that's okay. Look for the people who are going to make the best decisions for you in this process. All right. So let's talk just a little bit, and I'm going to be very brief about this because there are other materials out there, and we are going to get to avoiding probate in the estate planning 201. But for a will, what does it cover? It covers what ends up in probate. So if you have a bank account and there's no transfer on death or pay on death designation, all right, it goes into probate, and the will says here's where everything goes. If you do have a pay on death beneficiary on that account, then it avoids probate. There may be some documentation that has to go there, but it goes to that beneficiary, and it doesn't matter what's in your will. Same thing with life insurance. If you name, this is an important one. I'm naming my kids. Well, how old are your kids? Well, they're 5 and 7. All right, if anything happens to you and you've got your will and your will says they don't get anything until age 30 or 40 even, and they're named as the beneficiaries of the life insurance, well, the will, all those provisions giving age limits, they don't mean anything because that money goes directly to the kids. So it would be held up until they're legal adults, which is age 18. And I can hear everybody out there, whoa, that's way too young. You got $1 million policy and 2 kids, you're just going to dump $500,000 on them when they turn 18? That money's going to be gone. Exactly. So you have to make sure that these things line up. What about retirement accounts? All right. This is something where you have to make a tax decision. If you're naming someone to receive this and they're responsible and they're the beneficiary, that's who I want to get the money. All right, they've got tax options. They can actually put it into an inherited IRA, spread the taxes out over and distributions out over a 10-year period in their discretion. Great, that works. If you're naming the kids, they step in at 18 and start making these decisions. Maybe that's not the best thing. However, your financial advisor, unless they're a little more experienced in the estate realm, might go, what, you're naming a state to receive your IRA? Oh, the taxes are going to be horrible. Well, I want my kids to get it. And right now my kids are minors. They're at age 18. Who cares what the taxes are? They're just going to blow the money. Another attorney actually gave me this line, and it's perfect. Yeah, there is 100% tax on an irresponsible beneficiary because they're just going to blow the money. So, are you going to pay more in taxes by having it go to your estate and therefore be covered by the will and have that testamentary trust, have the age limits and the trustee involved in managing that money long-term for the beneficiary? Yeah, you're going to pay more in taxes, but it's going to be preserved and it's going to go according to your wishes. That trade-off is definitely more favored towards, yeah, go ahead, pay the additional taxes, because if the kids are just going to waste the money at 18, it's not worth doing it that way. All right, so that's kind of where we left. Again, it's just the basic documents. Let me do the rundown. Last will and testament, healthcare power of attorney, financial power of attorney, meaning the durable general power of attorney, the living will, and the nomination of conservator, and the bonus document. If you have kids, then it's the appointment of guardian for them. So what we're going to do now is we're going to turn it over in just a minute for question and answer. And I like to do this in 2 phases. First, go ahead and ask any questions on what we've got generally about this Estate Planning 101, what we've covered in this. But then we'll move into just kind of general open question and answer on other topics. So if you want to start talking about trusts or something else like that, okay, great. We're going to just giving you this ahead of time. There's going to be much more in the Estate Planning 201 and 301, and I think we've got a 401 and possibly a 501. So getting progressively into more complicated but valuable ways to do estate planning. But look, let's just open it up for those questions. Now, just one more special offer that we're going to throw out there. And now this offer has to be very, very limited in that it can only be for residents of North Carolina, age 18 and up. So this is kind of a perfect thing for my clients. Throughout the remainder of February, if you are going to put at least an appointment on the calendar or try to get one, and we're going to have that first meeting by the end of March in 2024, then we're offering to do the documents for $500 per individual. So it's those 5 documents, and all right, if you've got kids, we'll throw in that 6th one for the appointment of guardian. But that's, again, per person. And sorry, you don't get the big blue binder. That in itself is more than $100 worth of materials. So if you want that, we can add that onto it, and so you can get the big blue book and the dividers and all that other stuff. But at least we can take care of the documents for $500. Again, that whole thing expires. You got to at least get contact with our office by the end of February, and we're going to have to get that first appointment on the books during March at some point. After that, it's just going back to regular pricing. All right, so now we're going to move over to the question and answer section.
All right. Well, thank you all for joining us. Let's go ahead and open it up for questions. Now, I do want to mention one thing. There is another offer that's actually to help out a deceased high school classmate of mine. She was in a band called America's Sweetheart. She passed on from a rare form of cancer. But they had an album that was recorded and in the works. It just hasn't been released yet. So they've got a Kickstarter going in order to get that album finally released. And so what I'm doing is I am offering the membership for 1 year in the Client Resource Center. That's normally $197. I'm putting in a 50% off with that if you go ahead and use the coupon code Valerie, Valerie. That's 50% off. And I'll be able to see in the system that you use that coupon code. I'm going to donate the other half to that Kickstarter program to make sure that it gets out. So yeah, I'm not going to make anything off this. If you go to peaceofmindprogram.com, that's where that's going to be. And I'm also going to go ahead and put into the chat if I can. Give me a second here. All right, that's the actual Kickstarter link. If you want to go there directly, there's also benefits of helping sponsor that. They're trying to get to 10,000. I think it was somewhere around 7,700, so they're almost there. It was kind of her last wish to her bandmates, saying, look, just get this out, please. So that's her legacy. So let's go ahead and see if we have any questions. And if not, I've got a couple of common ones that I can review at the same time. So I'm not seeing anything in the chat just yet. That's okay. I often get this impression, well, wait a minute, I'm married. Everything automatically goes to my spouse. Why do I need to bother with the will? Well, all right, hang on a minute. A spouse doesn't necessarily inherit everything. In fact, in North Carolina, when it comes to inheritance without the will saying, here's where everything goes, anything that ends up in probate gets divided. If there are no children, then it's divided between the spouse and the parents. Okay, so the parents are getting something. If there are children, okay, sorry, the parents are cut out. But now suddenly, if there's one child, the spouse and the child split 50-50 after a specific amount goes to the spouse. And then it's 50-50. If there's more than one child, well, now, excuse me, spouse gets a third after that amount. And then 2/3 get split among however many children there are. So in that sense, the spouse may not even be the main beneficiary. So it becomes very important, even if you're married. Now, why does this question end up coming up? Because, all right, that's whatever ends up in probate. A lot of spouses will just kind of automatically own a lot of assets joint with the right of survivorship. And that happens outside of probate. And so there's that automatic inheritance there. So let's go ahead and check and see if we've got any specific questions out there. All right. I am not seeing any currently. So here's another thing, and I guess it comes down to medical. Oh, if I'm not married, don't my parents automatically make medical decisions for me, even if I'm over 18? Well, yes, but it's the two parents. If they're divorced, and there's not an agreement, then okay, that could be setting things up for a problem. And this is a story going back about 5 or 6 years. It actually hit the news, and it was just one of these really stupid freak things. There was a high school senior, and it was snowing out, and they decided, oh, let's get on top of the car, and we're actually going to do car surfing. And of course, they hit a pothole or slid. The guy falls off the roof, hits his head, ends up in the hospital. And the question comes up, should we take him off life support or not? Well, if he was under 18, then the mom just would have been able to make a decision. But because he was over 18, well, they're not guardians anymore. They are next in line. But there's mom, and then there's dad, who's off in Europe and unreachable. And so this lingered on for several days before dad finally came and approved taking him off that life support. But it left everything in limbo. Now, if they had the living will, or they had a healthcare power of attorney naming one person, none of that mess would have happened. So it's not an automatic thing, but they're kind of first in line to make these types of decisions, but it's at an equal level. Let's throw out the whole parents thing. What if it's you're divorced, but you've got 3 kids? Well, now all 3 kids are really jointly having to make decisions, and you may not ever want them to actually make those decisions. Now, this is actually something that kind of happened within my family, and I'm just going to say it very broadly, so I'm not being very specific, but she was divorced and 3 kids. 2 of them were not reachable. 1 of them was there, but they were very young. And so what's the first thing they do, even though they're 18, but the doctors are turning, let's make a decision. We can't get to your other siblings. What are you going to do? She calls dad. So in effect, the ex ends up making decisions. Now, everything worked out, but just think about that. If you're divorced, do you really want your ex through your child making these kind of decisions? You really don't. You want to name who you want in your healthcare power of attorney. All right, so let's go ahead and see. Do we have any other questions in the chat? All right. Then let me just talk very quickly about, all right, what is probate? It's the court process of overseeing an estate. So whether you do a will or not, you've got an estate plan. It just happens to be, if you don't have a will, the state has lined up, here's how your estate goes and who's first in line to be the administrator and handle all of this stuff. So you do have a government estate plan if you don't take the step to put in place your own plan. So when you do have that, again, it only covers what's in probate. So if you do have these pay on death designations or transfer on death beneficiaries, it does kind of pass outside of probate. Although, and I have to put this caveat in there, I have heard of a lot of institutions demanding paperwork from the court before they release it. And it's like, well, wait a minute, I thought this was avoided probate. Well, technically it's not in probate, but we want these court documents. All right. I don't care how fine you try to split that hair. The second you say to someone you have to go to a court to get a piece of paperwork, they look at it as being in court. So this is an issue. A lot of my clients actually come to us as a way to avoid probate. That's kind of what we're known for. We're big advocates of revocable living trusts. That's going to be in the 201 live stream, and that's probably going to be about 6 or 7 weeks out, but we'll go ahead and make sure we're getting it promoted out there. And we're going to talk more about avoiding probate at that level. All right, so I'm still not seeing any questions specifically in the chat. Look, let's open it up beyond what we talked about with the big 5 documents and that bonus document. We'll just open it up for whatever planning questions you've got. Now, if you start asking me about criminal law and real estate transactions and stuff like that, I'm probably just going to tell you, okay, sorry, not something that I'm versed in. But hey, if you got a question, go ahead and throw it out there. All right. Or again, let me reiterate those offers that I put out there. Plus, I'm going to go ahead and put in one more thing where you can get some materials for free. First, there's 50% off that client resource center, which includes the estate crash course, my book, Estate Planning Basics, a whole program on trust funding, and runs through here's what the usual process is for estate planning with my law firm. It's a lot of good materials that are in there. It's going to be 50% off if you use the coupon code Valerie. And I'm going to go ahead and put that in right now, all caps. And the free course that's out there is pretty simple. It's freetrustcourse.com. And that gets you the free course. And the last one, look, if you are a North Carolina resident, you're over 18, competent, you want to get your will and other estate planning documents done, those big five, or if a kid, we'll add on that bonus document for $500. Just go ahead and make sure you call the office, 919-844-7993, and we can get you started. $500. Sorry, again, you don't get the big blue binder, but you can add that separately. All right, just one last check to make sure we don't have any specific questions, and then we will call it a night. All right. Well, thank you all for being here. I really appreciate it, and I hope you got some good information. And if you get a chance, look, just go ahead and check out America's Sweetheart. If you go America's Sweetheart Band on YouTube, you should be able to check out Valerie and some of their stuff from a couple of years ago. And really, if you get a chance to help out with that Kickstarter, go ahead and help us out. Have a great evening. And as I always tell my clients, please stay safe, plan ahead, and enjoy life.